electronically to establish a quorum, and then we'll turn it over to Lisa Minton. Ms. Davis.
Here.
Everybody hear me? All right. Yep. Ms. Carpenter.
I'm present.
Mr. Newton.
Present.
Mr. Pepper.
Present.
Mr. Lawless.
Present.
All 6 members are here, and we have a quorum. I'll turn it over to Lisa Minton to start a meeting.
Good afternoon. The Metropolitan Board of Zoning Appeals is now in session for the regularly scheduled meeting of August 20th, 2020. My name is Lisa Minton, and I will be presenting the cases to the board for their review in today's public hearing. We are convened electronically pursuant to Governor Lee's executive orders number 16, 34, and 51 in order to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak and still conduct essential business of the metropolitan government. Before we move on with the meeting, the governor's executive order requires a motion to proceed electronically. Staff would solicit a motion to proceed electronically.
All right, we have a motion to proceed electronically. Is there a second?
Second.
That was Mr. Lawless.
Yes, sir.
I have a motion, I have a second, and any discussion? I'll call the question and start with Ms. Davis.
In favor.
Ms. Carpenter.
In favor.
Mr. Newton.
In favor.
Mr. Pepper.
In favor.
Mr. Lawless.
In favor.
I'll vote in favor, and we can continue electronically.
In order to convene this meeting pursuant to that executive order, board members are participating remotely, and we encourage members of the public to submit comments in support or opposition to the board electronically at bza@nashville.gov. We extended the deadline to submit comments, and any comments received by 12 o'clock noon yesterday, Wednesday, August 19th, were provided to the board for consideration prior to this hearing. Any comments received after 12 o'clock noon yesterday will be read into the record. Additionally, we have set up a voice mailbox for members to leave a message for the board on any case called on today's docket. Any messages that were received will be played for the board today. And I am here at the Sunny West Conference Room at a station that has been set up for anyone who wishes to address the board. Additionally, Board Chairman David Taylor is here, and social distancing measures have been implemented. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, the staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, if anyone is here wishing to speak in support of the appeal, they may do so. If any opposition is present, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period of rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the allotted 10 minutes. At the conclusion of each hearing, the board will deliberate telephonically and then vote on the case. The board is vested with the power to act on these cases under the provisions of Metro Zoning Code Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire zoning code and make it part of today's record. The Metro Code requires a record of these proceedings. And because the BZA meetings are recorded for Metro Nashville Network, and because the board is hearing cases telephonically, it is imperative that anyone addressing the board comes forward to the podium here at the Sunny West Conference Room and speak into the microphone. All speakers should identify themselves by name and address and then make their desired presentations. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, The case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an agreed party may appeal board decisions to the Chancery or Circuit Court within 60 days of the entry of the BZA order. Additionally, as per the BZA rules, an agreed party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. The permit must be obtained within 2 years for a board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled.
All right.
The consent agenda was published on August 14th and again August 19th, 2020, so that anyone wishing to pull an item from the consent could do so electronically. As previously stated, we are here at a station set up at the Sunny West Conference Room for anyone wishing to appear in person to pull an item from the consent agenda. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of those cases identified for the consent agenda, we will remove the case from the consent agenda and hear it in its regular order. The first case on the consent agenda is case 2020-160, located at 1402 Buchanan Street. It was requesting a special exception to reduce a street setback in the CS district. They're requesting a 10-foot setback versus the required 15-foot setback to construct a mixed-use development. Is there anyone here in opposition to case 2020-160? Seeing none. The second case on the consent agenda has received a notice of opposition as case number 2020-173, so that will be removed from the consent agenda and heard in its order with the hearings in today's docket.
All right, we have one item on our consent agenda, and that's presented to the board as a motion for consent. Is there a second?
Second.
All right, then Mr. Lawless seconded that motion. Any discussion? All right, we'll call the question and start with Mr. Lawless.
Agree.
Mr. Pepper?
In favor.
Mr. Newton?
In favor.
Ms. Corbinick?
In favor.
Ms. Davis?
In favor.
I'll vote in favor also. That consent agenda passes.
The first case to be heard on today's docket is case 2020-162.
Do we do the motions to rehear? We do those first, right?
We do have 2 previously heard cases requiring board action, which will be heard at the end of today's meeting.
Okay. We'll proceed with the 2 cases and then hear the motion.
Correct.
All right.
My apologies. The first case to be heard is case 2020-162, located at 1715 Castleman Road. They're requesting a variance from the 61.1-foot front contextual setback along Hunt Place. And in lieu of that, they're requesting a 50-foot front setback. And it's located within the R20 district to construct 2 single-family residences. Is there anyone here in opposition to case 122? Seeing none, I will go through the slides and then the appellant may come to the podium. Here's the parcel viewer map showing the zoning and location of the proposed site. Aerial view. The setback survey showing the contextual setbacks of the property. And an overview of the proposed construction with the setbacks and location of trees on the site. The appellant would like to come forward at this point.
Yeah, and we had heard this case at the last meeting and deferred it in part because you were available electronically but weren't present, and then we had a neighbor that had come with a legitimate issue of runoff, but it may not be as relevant to the criteria that we're trying to review for a variance, and so we deferred it to allow the applicant to not only talk with the neighbor or at least make an effort to talk to the neighbor, and also to be here to answer any questions that the board might have in person. So we are familiar with the case, and so you can tell us kind of where we are in the process.
Okay, Mr. Chairman, I appreciate that summary. And you're right, there were a few questions, issues that were not able to be addressed at that last hearing. So the first one was,
name and address for the record. Sorry.
I'm sorry, Dwayne Cuthbertson, 409A Merritt Avenue, Nashville. So the two issues that we weren't able to resolve at the last hearing were regarding drainage, the concerns of the neighbor to the backside of us. And then there were questions about the tree protection that we offered up with the site plan. So we committed to communicating with the Metro Urban Forester about that tree protection plan. And in coordination with the urban forester, we came up with a plan that he felt was suitable. So that plan has already been submitted for the record, but you'll see that we've shifted our site plan, specifically modified the building footprint closest to that tree that we're all attempting to save, so that there is at least 15 feet of separation between the trunk of the tree and the base of the proposed home. With that, we're also committing to installing a tree protection fence around that, the base of that tree, at least 15 feet in radius, but to the forester's suggestion, we're going to leave the space on the north side of that tree all the way to the road protected as well, so that it minimizes compaction. And then his suggestion, we'd never heard of this, he asked us to do some root pruning at the base of that proposed home's footprint, so that the roots get impacted uniformly, and supposedly that helps save a tree as well, instead of what typically happens is one root or a few roots get impacted and throw the whole tree off. And then the last thing that we committed to, if despite all of those measures within a year of this home being constructed, if for some reason that tree still doesn't make it, we are committed to planting at least 2 trees on that north side of that property of similar species. The trees will be 2 inches in caliper at the time they're planted, but the idea is that they're the same species, so over time they will grow and replenish, if not enhance, the canopy that's important to everybody in the neighborhood on that north side. Keeping in mind too that we have committed and we stay committed to protecting all of the trees on the Hunt Place frontage. So we submitted that, worked on that list with the forester, and he's agreed to those conditions, and we've submitted that list for the record. The modified site plan has also been submitted for the record for this case. The second issue, and apologies for not being in attendance at the last hearing, but the second issue was brought up by a neighbor toward the back side of our property, Holly Gleason. She had some concerns about drainage, and so we reached out to her shortly after the hearing, and we played a little email tag with her about her site, the impact from the construction that we did on a neighboring lot next to this particular property. We could never connect in person or on phone, but ultimately we did go out there and looked at the site, and we found a few issues for sure. So we wrote her an email last night. We were supposed to meet her yesterday at 10:30. We went out to her house. She didn't answer. So we followed up with an email, and we made a couple of commitments, and I'm happy to read those commitments into the record and then submit this email into the record. But we found a couple of issues. So the first one that we committed to, we told her we are going to improve the culvert, the ditch, in front of 1711 Castleman there's a small bump in it that appears it's likely redirecting stormwater into and down the driveway of 1711 Castleman toward your property, toward her property. Smoothing out that ditch will allow stormwater coming from upstream to stay in that ditch and move towards Belmont Park Terrace in front of the Castleman properties instead of heading her way. Second, we're going to install 3 catch basins on 1711 Castleman, 1 in front of the house and 2 in back of the house in the line of flow. These catch basins will catch the heaviest flows coming from the driveways and the house and redirect them toward existing French drains and toward Belmont Park Terrace, again, away from her house. Third, we're going to raise the landscape timbers at the back of 1711 Castleman adjacent to her property line. This will help redirect any heavier overflow toward the French drains behind 1711 and 1709 Castleman and ultimately send that water out to Belmont Park Terrace, again, away from her house. Finally, we've already started limbing back some of the trees on the back of 1711 Castleman Drive, so that in an attempt to give her a little more daylight, if you will. The area between the fence and her house is pretty barren. There's hardly any vegetation growing back there, and so we felt like opening up some of those trees would give her light, would help some of the vegetation grow in that space, which should help absorb some of the heavier stormwater toward her house. So we offered those measures up to her, and I'm happy to submit them for the record. We also told her that we want to stay in communication with her through this process. She has my phone number. She also has the owner of the company's phone number. The other owner lives 2 houses down. So if there are issues with what we do on Castleman Hunt, this subject property, regardless of how the board votes today, we certainly want to know about them so we can fix them while we're out there. So I'll offer that email for the record now.
Okay. Are there any questions from the board? And we'll note that the neighbor is not, there is not opposition. Right, Mr. Pepper?
Yes. Can you hear me okay?
Yes.
So my question is our urban forester, is he fairly confident that this changing the site plan and this root work will save this old tree? Did he express an opinion about what the likelihood is that the tree will survive the construction?
Yeah. So he didn't really express a likelihood, but I sat with him, looked at the site on Google Maps. I said he was going to drive by it, but then we came up with that list together after he had done some site investigation. There is a statement from him in the email chain that I submitted for the record. I don't have it in front of me, but I think it says something like this is far more than residential properties will do to save trees. So again, the list came from him as well. So I feel like he feels confident it's the best we can do other than just not developing the site to protect that tree. But then he also suggested if that tree dies, you need to plant some new ones. And so we are certainly committed to that as well.
Thank you.
Any other questions at this time? Mr. Lawless.
Can you show the picture of the tree that we're now discussing? Because I remember that was a major issue last time.
I don't think we have that slide available.
Thank you.
We do not have that slide available. Here's an aerial if that can help.
Yeah, I remember looking at the picture last time. Okay, thank you, man.
Any other questions? Did you have anything else to add?
I think I'd just add that we feel like we've taken a lot of additional steps that, if the variance is granted, will take effect for this property. But The tree is certainly one of those unique circumstances, but I'd also add that the setback of the houses to the south of us is really the unique circumstances. There's an 80-foot setback that factors into our average, which is really out of whack for this Hunt place. All of the houses on the other side are at 50. We think if that property hadn't just decided on its own to set back at 80, we probably wouldn't be in front of this board asking for the variance.
Okay. Ms. Carpenter, did you have a question?
I didn't have a question, but I did find a photo of the tree on page 239 of the board packet.
Okay, thank you. That was in the packet that the applicant originally submitted. If folks are looking for a picture. Okay, with no other questions and nothing else to add, we'll close the public hearing and discuss. It does seem, I do appreciate the applicant's willingness to reach out to the neighbor and the efforts that the applicant has and the things that the applicant's committed to correct some issues that may have been present in a previous construction site that's not this site, but also to ensure that this site doesn't duplicate some of those. It sounds like that concern has been addressed from our last meeting, and I think moving the house back and working closely with the urban forester has also worked pretty hard to address the tree issue, and so I'm inclined to approve the variance. Not sure how everybody else feels. Ms. Carpenter?
I agree with you for those reasons.
Mr. Lawless?
I'm just trying to get my head around the size of the trees. If the one that's there dies, just exactly how much are we talking about? I mean, it takes a while for a tree to grow, especially, I mean, what type of tree are we talking about that he's going to put in there? He said similar, but those types of items are where I'm really having a difficult time with this one.
Or would you be, I think he said a similar tree, and it's an oak tree, so I'd assume it would be an oak, and he said a 2-inch caliper. Are you suggesting it needs to be a 3-inch caliper or a slightly larger tree if the current one dies, or would you rather have a...
Well, I'm not a forester by any stretch of the imagination, so I would not have a clue whether a 3-inch would be, you stick it in the ground and it's dead shortly thereafter, or anything like that. So,
well, and it sounds like he's spent a pretty good time with the urban forester to come up with a list of ways to save the tree and criteria if they don't.
Yeah, and if they don't, but I mean, there are several different types of oak trees. You've got red oak, you've got pin oaks, you've got all different types of oaks, some of which take a long time. I mean, if he had said he was going to stick a hackberry, I knew what my answer was right off the bat, but oak trees are slow growing. And maybe if we could open up and he could just tell us, that would help me out. And I should have asked that question when he was still answering.
I'll open the public hearing and ask for clarification on the type of tree.
Sure, Mr. Lawless, we spoke with the forester, and the idea is if this tree dies, we would plant a similar species, one that would eventually grow to a similar or greater height that would not just replenish, but enhance the canopy. And you're right, there are certain oak trees that grow slower than others. A 2-inch caliper tree is what's fairly standard with establishing new trees on any particular site. We're open to a 3-inch caliper tree. We use a commercial grower and landscape company to do all of our planting. So if if we purchase those 2 new trees and they happen to die, I don't know what the time frame is, 6 months or a year, that company will go out and replant them. So we're open to a particular species, Shumard oak. We'd also talked about sycamores, even though they're a little bit different. They grow pretty fast, and they can get to 100 feet tall. But the commitment was a similar large canopy deciduous tree.
Any questions from the board? I will reclose the public hearing. Any other comments? Mr. Lawless.
I just want to say I appreciate the comments by the applicant and his response to my question.
Okay. Without further comments, I'll make a pass at a motion that we approve the variance for front setback based on the hardship of not only attempting to save a mature tree, but also the anomaly in the neighboring front variances that may have skewed the average in a way not to the applicant's favor, and that the conditions be based on those submitted by the applicant and outlined by the urban forester to do everything as outlined to protect the tree and to plant a similar species. I would say a 3-inch caliper tree, since they are willing to do that should this tree die. And that's my motion.
I'll second your motion based on the 3-inch caliper tree.
All right, then, as Mr. Lawless seconded, has a motion as a second. Is there any other discussion? All right, we'll take a vote. Mr. Lawless.
In favor.
Mr. Pepper.
In favor.
Mr. Newton.
In favor.
Ms. Carpenter.
In favor.
Ms. Davis.
In favor.
I'll vote in favor also. That motion passes unanimously. Good luck. Next case.
The next case to be heard is case 2020-173, located at 201 Grizzard Avenue. They're requesting a variance from a landscape buffer requirement along a south property line within the CF district to construct a mobile home park. They propose to install opaque fencing and retain the existing tree line as much as possible as part of the proposed development. We did receive a fax of opposition, which I can read into the record. It was received, I believe, yesterday morning. And it states that this letter is to inform you that we oppose a mobile home park on this property. Sincerely, TMF LLC, and I believe their signature is Travis Ford.
And that's the only letter of opposition we have?
Letter of opposition. It was received via fax yesterday.
And so this, yeah, and just to be clear, the variance request is not to build a mobile home park. We have no control or issue, or what they're doing is not at all before the board.
Correct.
But the variance from the landscape buffer, which is required, is what we're talking about. So, I mean, I appreciate them not wanting a mobile home park, but that's not an issue that we are able to address today.
Correct. And we do have an email of support from the urban forester, assuming that there's no opposition.
Is there any opposition present?
Any opposition present?
Okay. There is opposition present. Okay. So, is the applicant here?
Is the applicant here?
Okay. Yeah. If you all would come forward, and because there's opposition present, then each side will have 10 minutes to make their case. And whatever time you don't use up front, you can save for rebuttal after the opposition has a chance to speak. So you'll speak, the opposition will speak, and then whatever time you have left in your 10-minute presentation, you can use to rebut the opposition. So if you would, come state your name and address and tell us what you're trying to do.
Yes, sir. My name is Randy Harper with Goodwin Mills Kaywood, engineer for the project. Also have Mr. Jeff York with UMH Properties as the owner of the property. What we're doing here is we've got an existing mobile home park that's been approved in the early 80s, if not before then. The first phase has been built out, and since then, it was actually a PUD that was approved, and we went back about started 3-4 years ago working on the second phase of the project. We have that approved through Planning Commission for the second phase, which actually reduced the number of mobile homes that would be built from the original approval of about 280 something new homes to we've reduced that down to 155 on the second phase. What we're proposing is a fence along the south property line, as you can see in that exhibit there. We would start at the interstate and go all the way down this phase and tie into some existing fence. It would be an opaque fence as part of a buffer.
And how tall would that fence be?
6 feet, correct. The 6 feet opaque fence. I've also talked to Council Lady Toombs as late as this afternoon, and she was also in support of it. She was going to submit an email stating her support for the project as well as for the buffer or the fence in lieu of the buffer. This is the first we've heard of the letter of opposition. It was right before I left to come here. So I have not talked to the entity that presented the opposition, but I think the owner's actually spoken to the adjacent property owner to the south, which is a straight zone piece of property. It's also an existing mobile home park that's been there about as long as Holiday Village has.
So the fence,
buffering the mobile home park from the mobile home park.
So the fence that you're talking about, so instead of a landscape buffer, you're going to put an opaque fence, and it's just between you and another mobile home park.
That's correct, and we'll maintain as much of the existing trees as possible between the two.
Okay. Is there anything else you'd like to add at this point?
Mr. Jeff, do you have anything that you'd like to mention to the board?
No, just other than...
Yes, sir, and yes, state your name and address.
Okay. UMH Properties, Morgantown, West Virginia.
Okay.
I just wanted to add that the existing vegetation really wasn't quality vegetation. There were a few trees, but it was mostly grass, shrubs. Just
okay.
Felt that the barrier was much better as far as appearance and security.
Okay. All right, and so if you have nothing else to add at this point, you'll have 7 minutes for rebuttal, and we can hear from the opposition. So if you would come up and state your name and address and tell us why you're here.
Amy Bird, 110 Street, number 24. I actually just have some questions because maybe it's not a problem. The way that the notice that we received, the way that it was stated, made it sound like, but for them getting this variance, then it wouldn't be that they would allow. Like the verbiage says, the appellant requested a variance from landscape buffer requirements. Should this request be approved, it would allow the applicant to permit a mobile home park. So we assumed that if it wasn't approved, then a mobile home park would not be permitted.
Right.
So that's number one, what we thought. Number two, I guess the question is, what is the reasoning for not doing the landscape buffer? Is that going to allow more homes to be in that area? Or I guess I'm just not clear on the reasoning behind not wanting to do the required landscape buffer.
Yeah, and that may be questions that the applicant can answer, but the first question, and that may be just the way the letters are worded, but they, you know, the issue of whether or not they have a right to a mobile home park is not here. So if they put in the buffer, then they would not even be here. They'd just be able to do their mobile home park.
Right, totally get that.
And so what they're saying is there's a hardship of some sort to not be able to do the buffer, and I think and I'll let them, they can quote tell their case more when they get back, but part of it has to do with the 50-foot easement that Piedmont Gas has that crosses through the property, which impacts the way they deal with their property. And then, of course, the other argument was that, between that fence and the fence basically just separates another mobile home park. And so a lot of times what we see on this board, and again, I can't tell you how the board's going to react, and we're hearing the case at this point, but a lot of times you'll have two differently zoned areas that have the same function, but because the code defines one in a certain way and another, you got this buffer requirement. And so it's meant for, if you built a warehouse next to residential, well, you got to put a buffer in. But if you build residential on the warehouse space and, it's all residential, then you think, well, it's a technicality to build a buffer, but in that specific case, maybe you don't need to. And so that's what they're saying is I got a mobile home park next to a mobile home park. I'm still going to put a fence in, still going to secure it, but it's not the spirit of the law would say the buffer is not necessary. That's their case. So, but in terms of your first question, us denying this would not keep them from putting in a mobile home park. They would either have to put in a buffer or design it in a different way or do something to meet that requirement. But they can talk more specifically what their hardships are, but they talk about the fact that it's mobile home to mobile home and that they have a gas pipeline easement that impacts their property.
Gotcha. And my final question would be, if they were not permitted to not have the landscape buffer requirement, what would that mean? Is that going to mean that there would be less available spots for mobile homes?
Yeah, that would be a question that they would have to answer. I don't know.
Okay. Awesome.
I mean, yeah. So I'm not trying to answer your questions as best I can as a board member because you came out and are interested, but at the same time, I'm not trying to make a case for them either because we're just trying to hear it.
That's the way that it was written.
Yeah.
And like, if they don't get this, then a mobile home's not going to be able, mobile home park's not going to be able to be there. But, I mean.
We're going to have you the microphone to address the other members.
But if that's not the case, that if
Right.
they don't get it, then obviously that's a different story. But I am interested in knowing if they didn't get it, what would that mean? If it would mean less spots available, which obviously I would favor of less.
Okay.
But, okay.
All right, thank you. Well, we will hear from the applicant. Now the applicant has 7 minutes and a second for rebuttal. If you all would come back. And I guess that maybe the best thing to do, is, if you don't mind, is just to refresh my knowledge and that of the board of just the specific hardship, which I think you talked. I may have said both, but if you would, in your own words, just say what the hardship is that would warrant this variance from your perspective.
Yes, sir, Mr. Chairman. Just to kind of address all the questions and comments, the mobile home park was approved back in the 80s. This expansion went through the PUD process about 2 years ago when we completed the process, so it has already been approved. Putting the buffer in would not decrease the number of mobile home spots in the new construction area. It would remain the same. Essentially, the hardship is, if you kind of look back at this development historically, it had been, the original design had been started, had construction started on it. They'd cut roads through, had put some utilities. I think even had looked at or had started a few foundations in the past. So a lot of the existing tree canopy had been removed in previous iterations, and so what's grown up is just a bunch of thick, scrubby stuff that wasn't very visually appealing, and it's more of a nuisance than anything else. What we proposed here, one, for the fence for security purposes, we just get a lot of transient traffic back and forth coming adjacent to the interstate, so to try to cut down on some of that. And that was one of the items that the adjacent property owner to the south that were buffering the other mobile home park. That was one of the things that they were really excited about, was putting the fence there to help prevent some of the transient traffic through their property as well. So that was one of the items. And then I said most of we have a 50-foot Piedmont easement there with a emergency access that will be for fire, police, and the gas company provides them another means to access the property through an emergency means only. So like a keyed gate where they could get in and out. But that's essentially what the hardship is.
Okay. Are there any questions from the board? Was there anything else that you'd like to add?
Yeah, just to reiterate that there's no changes to the number of homes, the lots, the roads. The only area we're talking to being affected is that 10 feet off the property line.
The buffer. Okay. Mr. Pepper.
So I want to ask the applicant, I want to make sure I understand the easement part, because so there's an easement there, and obviously you cannot obstruct an easement, and I think I hear what you're saying is that the fence allows you to allow the holder, the beneficiaries of the easement to have the access they need, whereas if you leave in plants, essentially, you're not going to be able to do that. Is that what I'm hearing?
Yes, sir, that's correct. Over a portion of the property, it's not over the full length of that line, but there's a 50-foot gap there that Piedmont actually maintains now and have for years, where they completely keep that area clear. There's actually 2 high-pressure gas mains that run north-south, kind of parallel the interstate through the middle of this property. And that area we could not buffer due to the easement holders requirements, and the code doesn't actually require us to buffer it across the easement either. But the fence will allow us to provide the security we need for the residents for both mobile home parks. It provides us the security for them, and then a way to get the emergency vehicles as well as maintenance crews for the easement holder.
Okay, thank you.
Thank you, sir.
All right, anything else to add? We'll close the public hearing. Discussion. Yeah, I mean, this was originally, on the consent agenda because of the reasons that we talked about a minute ago, with being mobile home park to mobile home, next to a mobile home park, and, the urban forester having no opposition, and the gas line easement, and understand, some of the concerns of the opposition in terms of the mobile home park itself, but that's not on our plate. So I didn't have an issue with the request as presented. Any other thoughts? Mr. Pepper.
I don't think I do either. If I'm understanding the easement part of this correctly, and then I think the easement creates a hardship as I'm understanding it.
Okay. Any other comments or thoughts? Well, I'll make a motion that we approve the variance from landscape buffer based on the Piedmont gas easement through the property, and the situation where the 2 uses of the property between where the buffer would go have the same use, and therefore have a less of a code need for that easement, and have that under the condition that they construct a 6-foot opaque fence as presented in their plan instead of the easement, or I'm sorry, instead of the buffer. Ms. Carpenter.
I'll second that motion.
Have a motion as a second. Is there any additional discussion? I'll take a vote. Ms. Davis?
In favor.
Ms. Carpenter?
In favor.
Mr. Newton?
In favor?
Mr. Pepper?
In favor?
Mr. Lawless?
In favor.
I'll vote in favor also. That motion passes. Good luck. Thank you. All right, so we now have two motions to rehear previous cases, and I know we've had some new members, a new member, if not more, since we've had motions to rehear cases. So if I think Mr. Poole is on the phone, so I'd like our legal counsel to just give us a quick overview of what it means for this type of motion and what we should, how we're supposed to consider that.
Thank you, Chairman Taylor. This is Quan Booth from the Metro Legal Department. So what a rehearing is classified as, it's a post-hearing request. And so I think the importance of this rule is that it's not meant or is not intended to allow applicants to basically relitigate the original case. That case was fully heard and voted upon by the board. So the rule is not intended to allow any applicant to get a quote-unquote second bite at the apple. What the rule specifically states is that no such request to grant a rehearing shall be considered unless new evidence is submitted which could not have reasonably been presented at the previous hearing. So all the information today, the question is going to be, could this have reasonably been presented at the previous hearing? And then another important portion of that rule, and again, I'm reading from the Board of Zoning Appeals rules. That was 10A2, and then this is going to be 10A4. Motions to rehear will be deliberated and decided based solely upon the filings. No oral arguments or live presentations will be made to the board in conjunction with the motion to rehear, and that's, again, Rule 10A4. And so the point there is, it's not intended to allow applicants to get up and explain and make a second presentation to the board. It should be clear in their filings whether or not this information could have been reasonably presented at the previous hearing. So that's basically all I have, but I'm certainly here and present should the board have any questions for me.
Mr. Lawless.
In our consideration, Quan, do we need to take into account the possibility of notices being either accurate, inaccurate, or the circumstances that we find ourselves in today, or we have for the last 6 months or so because of the Chinese coronavirus?
I don't know if there's an allegation that the notices weren't appropriate, but if someone does state that they didn't have appropriate notice and they wanted to present something today, I think that probably could be a consideration where they could say, hey, I could not have reasonably presented this evidence at the last hearing because the notice was incorrect or the notice didn't comply with the law. Now, if that notice did comply with the law, then I would be hesitant to grant relief based upon a notice that was compliant.
Okay. So that to have someone requesting a rehearing or reconsideration, then would not just the mere statement that notice may or may not have been sufficient to meet even the minimum constitutional requirements? I'm asking now, I'm posing, because hell, I've never lived through a pandemic, and I know how bad the mail is out there right now. So I'm just posing some thoughts and some questions that I have.
No, I understand. To me, though, it's an objective standard. I don't know that it's someone simply saying I wasn't properly put on notice. I think if the applicant at the time mailed out the notice or placed the notice sign in their yard and comply with the provisions of the zoning code, then I would say that they have met that objective standard. I don't know that there's a lot of subjectivity to it. They either mailed out the notices to people within appropriate distance, they either placed a sign in their yard, they either paid the application fee, they either did or they did not do those things.
Thank you, sir.
Any other questions for Mr. Poole? There are, I think there are representatives of both cases here, and like I said, want to be respectful of our rules and follow our rules. And if there are any specific questions, again, without relitigating the case or hearing what the future case will be, that is an option for the board, just FYI, since you all are not physically present here. So I guess the first case we'll take up is, do we need to introduce that? Or
The zoning administrator, John Michael, will introduce these cases.
all right, so I'd call on the zoning administrator to introduce the first case, which is 118, which we'll call the billboard case.
The introduction is incredibly brief, Mr. Chairman. John Michael, Metro Zoning Administrator. As you know, this was a case number 118 that was heard previously by the board. I think the order was dated June 4, or perhaps the hearing was June 4 of 2020. I think that was the order date, perhaps. And you have council's extensive brief. His letter is, in fact, about 4 or 5 pages, and then a number of documents submitted in support of that brief, supporting his motion for rehearing. A reminder for the board, just as your council alluded to, and in fact expressly stated on some of these points, in the event that after the board's deliberation there's the decision to grant the motion for rehearing, we would then, through staff, administratively set the date for the next rehearing of that case. Proper notice requirements will be pursued once again, and everybody will have the opportunity to participate in the BZA hearing as though this case had not been heard previously, in case that was left in doubt for any of our newer members of the board. The case itself speaks for itself. You remember the case, you remember the deliberation, you remember the subsequent vote to uphold the zoning administrator's determination to cancel a permit that had been issued for a billboard on 2nd Street, just across the river on the East Nashville side of the Cumberland. The documents that have been submitted by opposing counsel lay out their arguments in support of the motion for rehearing. With that, Mr. Chairman, that's the introduction. We'll leave it back to you and the board members to deliberate accordingly.
Mr. Lawless, did you have your hand up for Mr. Michael?
Well, it's not so much for him, but someone is either flipping pages or putting something in front of the mic, and it's sort of breaking up a little bit, if at all possible.
Okay, yeah, that may have been me. I apologize for that. Were you able to hear?
I got most of the information. It's just sort of a little loud back there. Mr. Chairman, Can you move your pages away from your mic, pretty please?
Yes, I think they're done. I was looking up on one of the. I think you all got an electronic copy, as we all did, of the applicant's motion, and I got a paper copy, which is several pounds. It's actually a very big packet and thorough packet, and I was just trying to get the, to me on these, and we don't hear very many motions, but the piece that one that's I think compelling enough to consider, and another one that is maybe less compelling to me, but is still worthy of consideration, is the one is the new state law that happened on June 22nd, which I think is something, and maybe Mr. Poole can help us on this one too, but that is something that. Again, since this is an applicant who got a permit, built a project, then it was determined that that permit was issued in error, and they're trying to justify that. It may be worth our time to say, if the new state law does impact this in a way that benefits the property owner and the applicant, then it may be worth at least hearing about that. And then the orientation issue, which I think and I'm not sure exactly how to say it, but because I'm not sure what I want to say other than it is, to me, a confusing aspect of this, and there was a fair amount of evidence presented by the applicant, arguably may have been available prior to the hearing, but I do think the applicant in their application talks about the discussion that they had and the impression that they got that this was not an area of concern, and then in their brief and opinion, it became an area of concern. So I guess those are the kind of the two areas that I'm leaning on, and you all may have other thoughts as you've read it. But and Mr. Poole, you had your hand up, and I may have nattered on too much for you to remember what I'd actually asked, and I apologize. But
No, that's okay. So I did see there was a reference to the state law that was passed on June 22nd of this year. Obviously, that would have been a couple weeks after the hearing. I could not tell from the filing how the new proposed state law impacted this particular case. I mean, I do that law, from my understanding, was drafted in response to a case out of Memphis where the Sixth Circuit determined that the entirety of that act that related to billboards was unconstitutional based upon like some content speech. And so the entirety of that act is multiple pages, I think maybe around 40. So I haven't read all 40 pages of it, but my understanding of the act that went into effect on June 22nd is that it was in response to a Sixth Circuit appeal case from last year that dealt with declaring the entirety of the act unconstitutional. So this year, to remedy that, the legislator amended or made some changes to the entire act.
But if the applicant, if the board, and I guess if the board felt like that could have an impact one way or the other, then that would be a legitimate reason to rehear the case as information that wasn't available at the original hearing. Is that correct?
Right. If the board felt that this new act somehow impacts this particular case, then that could be a basis. Again, I don't particularly know. It wasn't really fully fleshed out, but if the board found that this new act was a reason, that could be something that the board finds was reasonably not available or could not have been reasonably presented at the previous hearing.
Okay. Any other thoughts from the board?
Mr. Chairman, we're talking about case 118 right now, correct? We're not talking about
the billboard case.
Together. Okay, I just wanted to clarify. And it's undisputed the state law went into effect 2 weeks after the initial hearing and ruling of the board. Is that correct?
Well,
one second, I can.
Well, it said, it says on June 4th is when we had our hearing, the board denied, and then on June 22nd, the governor signed. That's in their materials, which I have no reason to dispute. So it does look like that we heard the case prior to this new law taking effect.
Right. I'm looking at House Bill 2255. It says that it was passed on June 11th of 2020. Approved on June 22nd, 2020. Obviously, this act would have been passing through the legislature during the time of the last hearing, but as far as its actual adoption and becoming full effect in law, it was June 22nd of 2020.
Mr. Pepper?
So, Mr. Chairman, if we do rehear this matter, could we, if we vote to rehear it, can we strictly limit the rehearing to the application of this law if it applies retroactively, if it even applies retroactively? Am I making sense? In other words, if we vote to allow a rehearing, is it permissible for us to limit the rehearing to the issue of the impact of this new law?
That may be a question for Mr. Poole.
I think they would be entitled to the hearing. I think certainly the board could. I think any applicant, if they're told, I think they would. First of all, I think they would just have an open public hearing. But I think most wise applicant would want to know if the board wants to hear information on a specific item. They would probably use their minutes judiciously and try to affect or try to speak on that specific topic. So there's a rule that allows a public hearing. If the board wanted to suspend that rule, then yes, I think you could probably limit the hearing to this specific topic. However, even if you didn't do that, I think the applicant probably would be wise and on their own sort of tailor their presentation to this specific issue. But I think it could be done either way.
Okay, I understand. Thank you very much.
Any other thoughts from the board? Mr. Lawless.
I assume that the governor did pass the statute and he didn't let it go into effect on a pocket veto.
Yeah, it was written in the brief that he signed it on the 22nd of June.
Thank you.
Oh, well, Mr. Michael just gave me a signed copy, and it looked like he signed it on the 22nd of June.
Thank you.
And it passed on the 11th, and he signed it on the 22nd. Either electronically or with a big, bold pen, like he meant it. I don't know. So, Ms. Davis, did you have your hand up?
No, I didn't. I'm sorry. That was an accident.
All right. Well, I can't say I feel strongly one way or the other, but I do think that if there's possibility of information that would impact it, and I don't know that this is relevant, but I'm just my own opinion that since it was approved and then built and then deemed permit issued by a mistake, then if I'm personally 50-50 and think that there's a case, and I'm more inclined to say I'll hear it again. And certainly the applicant is present and has heard the issues raised by Mr. Pepper and others about what that focus should be. But I'd also, while I think that the orientation issue is one that we certainly could have known at the time, there's a lot more information, and so I personally would not prefer to suspend the rules if we choose to rehear it and allow for a rehearing of the merits of the whole case. But that's just one opinion of 6, so I'm not sure what you all think. Ms. Carpenter.
I'm like you, and I think when it's a 50-50 that we should err on the side of caution and rehear the case. So I can make that a motion and then we can discuss it.
All right, there's a motion to rehear the case. Mr. Pepper?
Well, I don't know.
I was going to say in the And just in the motion right here, let's just make sure we state with specificity what the information was that wasn't available for the purposes of the record.
Oh, sure. I would say the new state law wasn't available at the time of the hearing. Does that sound good?
It does.
Okay, thanks.
So this is Mr. Pepper. Yeah, I will second that motion and say that this is the first request for a rehearing that I recall where it's where someone is coming forward with something that indisputably was not available to them at the time of the first hearing, because if this law was enacted 2 weeks after the first hearing, then it obviously wasn't available. So I second the motion and support it, obviously.
Okay. Any other questions or comments or thoughts? Discussion on the motion? All right, seeing that, Mr. Newton.
My only question is, I mean, is there any way that this law is applied retroactively, or, you know, what does it matter if it was enacted after the decision? Why does it matter for the decision if it's 2 weeks later? I'm curious if anyone has anything in the law that applies it retroactively.
This is Mr. Pepper, and I don't know, Mr. Newton, and I think that if it doesn't apply retroactively, that it'll be a very quick hearing, and it may not. And if it doesn't, then in my mind, it's a very quick hearing. I don't know right now, and I think that maybe it does, maybe it doesn't. But if it does apply retroactively, then the applicant ought to have a chance to tell us that.
Okay, thank you.
Any other discussion? All right, I'll call the question and we will vote. Start with Ms. Carpenter.
In favor.
Mr. Pepper.
In favor.
Mr. Lawless.
Against.
Ms. Davis.
In favor.
Mr. Newton.
Against.
And I will vote in favor, and so that motion passes 4-2. So they will work with the code staff to get that back on our docket. And the next case that you'll hear from the zoning administrator is for a motion to rehear 5611 Franklin Pike, which was the special exception we passed with 6 residential units on Franklin Pike with a 0-foot front setback and 5-foot rear setback.
And Mr. Chairman, thank you for identifying the particulars of the case. The only items we want to make sure are reintroduced to the board with this case number 141, which you heard somewhat more recently, was that we did receive today a brief letter from the district council member, Angie Henderson, that is not part of your packet. I wanted to read that into the record because it is very brief, and I know that Mr. Murphy, counsel for the developer and original BZA applicant, has not seen this yet, but it speaks for itself. It's a brief letter dated 8/20 of 2020. Board members, regarding case 2020-141 at 5611 Franklin Pike, it has come to my attention yesterday afternoon and this morning via numerous emails that the city of Oak Hill has submitted a letter requesting a rehearing of case 2020-141, 5611 Franklin Pike, which granted variances to permit a 0-foot front setback and a 5-foot rear yard setback, and a special exception to permit the development of 6 residential units as an adaptive residential development within a CL district. Prior to this morning, I was not aware that you would be considering this request today. I support a motion to rehear. Thank you, Angie Henderson, council member, District 34. So that will be added to the record and has now been read into the record for the board's, consideration. You have in your packet a letter from the city of Oak Hill, which essentially was their brief in support of the request for a rehearing. We also have in the packet, I think it was a late ad, that's probably near the end of your packet, the August 18, 2020 letter from counsel for the former BZA applicant and the developers on this. That's a letter from Mr. Jim Murphy, again dated August 18, 2020, laying out their arguments in opposition to the motion for rehearing. Certainly staff will be happy to answer questions if we can, but I think that your filings will speak for themselves. Mr. Chairman, I'll be available if you have any questions.
Mr. Lawless, did you have a question?
Wasn't so much a question is, but I have to, as I did last time, abstain from voting on this matter, and I actually think that I have a pending case with these folks before the city court presently. So I think my questions at the beginning of this sort of outline what my thoughts were, but I will be abstaining.
Okay. Any thoughts from the board? This case seemed to me to come down, at least from the applicant here. I guess this is one of those two where the applicant is the city of Oak Hill in this case, because they're the ones that asked for the motion. But there were only two arguments that I thought that they had, and one was whether or not this was in the urban district or general services, and the property owner submitted an affidavit saying it was in the correct zone. And then the other was the future street work, and those to me, both of those arguments, or all the arguments that were made, could have easily been made before and known, and these were people that participated actively, and at least through correspondence in the hearing. And I don't think physically present, but were had submitted letters at the original hearing, and neither of those points were made. And I think that even if the first one were valid, it seems like that would be maybe an opportunity for them to, through an item A appeal, challenge the issuance of a permit, rather than have us rehear the hardship or the criteria and the special exception for a variance. So I don't personally see a reason to rehear this, but again, throw that to the board for your thoughts. Ms. Carbonek?
I agree with you, and that was an interesting comment about it could be a potential item A appeal instead of a rehearing. But I agree with you, what you were saying.
Okay. Yeah, and it may not be. I mean, given the affidavit that came from planning, it may not. I think it lost its teeth. But had that not been there, then I think it would have. Agreed that might have been the more appropriate. The appropriate response. Any other comments? Well, I'll move that we deny the motion for a rehearing on this case, based on the lack of any new evidence or evidence that could not have been presented at the previous case. Ms. Carpenter?
I'll second.
I have a motion and a second. Any discussion? And we will vote. Start with Ms. Carpenter.
I'm in favor.
Ms. Davis?
In favor.
Mr. Newton?
In favor.
Mr. Pepper?
In favor.
Mr. Wallace has abstained. I'll vote in favor. That motion passes 5-0. And I think that we're done. Thanks, everybody. Have a great day.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.